अध्यक्ष जी, मैं सदन को आश्वस्त कर सकता हूं कि 1860 से लेकर 2023 पर 23 तक अंग्रेजों ने बनाए, अंग्रेज पार्लियामेंट ने बनाए हुए कानून के आधार पर इस देश की क्रिमिनल जस्टिस सिस्टम चलती रही। इसकी जगह भारतीय आत्मा के साथ ये 3 कानून अब प्रस्तावित होंगे और हमारी क्रिमिनल जस्टिस सिस्टम के अंदर बहुत बड़ा परिवर्तन आएगा।
With that announcement, it's curtains on British-era criminal laws for India. A complete overhaul has been proposed by the Modi government in order to ensure timely verdicts, transparency, and ease for victims. They will bring a transformative change in the Indian judicial system by prioritizing the delivery of justice over punishment. The 3 new bills were introduced by the Home Minister Amit Shah in Lok Sabha. The Bharatiya Nyaya Sanhita Bill 2023 replaces the Indian Penal Code. The Bharatiya Nagarik Suraksha Sanhita Bill 2023 replaces CrPC. The Bharatiya Sakshya Bill 2023 replaces the Indian Evidence Act. The Bharatiya Nyaya Sanhita Bill 2023, which replaces the 160-year-old Indian Penal Code, will contain new numbers for some of the most commonly used sections, numbers that have been a part of our popular culture for decades, like 420 for cheating or 302 for murder. That will soon be a thing of the past. There is no section 420 in the Bharatiya Nyaya Sanhita Bill. The offence of cheating is covered under section 316, and the punishment for cheating may extend up to 7 years in prison along with a fine. Murder is not under section 302 in the proposed bill. It's covered under section 99 instead. And here too there is a distinction. Whether it is an individual or group, like in the case of mob lynching, they can be punished with death or with imprisonment for life. Currently, IPC section 375 defines the offence of rape. The proposed Sanhita does not have a section 376. Rape is defined under section 63. Whoever commits rape shall be punished with up to imprisonment for life. For gang rape, there's a provision for punishment of 20 years imprisonment or life in jail. Death penalty is the maximum punishment for gang rape of a minor.
इसमें महिलाओं का और बच्चों का विशेष ध्यान दिया गया है। अपराधियों को सजा हो इसकी चिंता की गई है और पुलिस अपने अधिकारों का दुरुपयोग न कर पाए, ऐसा भी। इसके अंदर राजद्रोह जैसे कानूनों को एक और हम निरस्त कर रहे हैं, तो दूसरी ओर धोखा देकर महिला का शोषण करने वाले और मॉब लिंचिंग जैसे जघन्य अपराध करने वालों को दंडित करने का भी।
The word sedition does not exist in the proposed Sanhita. Offences of the nature described as sedition in the IPC are covered in section 150 of the proposed bill. They are described as acts endangering sovereignty, unity and integrity of India. Whoever commits such an act shall be punished with imprisonment for life or with imprisonment which may extend up to 7 years. Defamation, under which a court in Gujarat convicted and sentenced Rahul Gandhi to 2 years in prison and triggered his disqualification as an MP, is covered under section 354 part 1 of the new Sanhita. Here, for the first time, community service has been introduced as a punitive measure. While the maximum punishment continues to be 2 years in jail, a convict can be left only with an order to provide community service in the wisdom of a court. Under the proposed Bharatiya Nagarik Suraksha Sanhita, which is the bill that seeks to replace the Code of Criminal Procedure, a person accused of crime can be tried and convicted even if they are absent. While the Code of Criminal Procedure currently provides for recording evidence in the absence of the accused, a trial in absentia is not permitted. If an accused is absconding, it is the duty of the state to locate them before the trial begins. But the bill provides that if the accused is not present, the court can proceed to try them 90 days after the date on which charges are framed. A trial in absentia is prescribed in stringent anti-terror legislation such as the UAPA. Here the onus is on the accused to prove they are not guilty rather than the state trying to prove guilt against the accused. The bill states that statement of the accused can be recorded through video conferencing. Summons, warrants, documents, police reports, statement of evidence can be done in electronic form. The search and seizure of articles and properties, the visit to a crime scene by a forensic expert, all must be audio-videographed. Recording of the victim's statement shall also be audio-videographed, preferably only on a mobile phone. The Bharatiya Sakshya Bill, which would repeal the current Indian Evidence Act, will bring precise and uniform rules for dealing with the evidence during the trial. The bill makes electronic or digital records admissible as evidence, so they will have the same legal effect as paper documents.
मान्यवर, एक कानून में हमने लक्ष्य रखा है कि दोष सिद्धि के प्रमाण को, कन्विक्शन रेशियो को 90% से ऊपर लेकर जाना है। ये हमारा लक्ष्य है। इसलिए हमने एक महत्वपूर्ण प्रावधान किया है कि 7 वर्ष या उससे ऊपर की सजा जिस धाराओं में है, वो सभी क्राइम सीन पर फॉरेंसिक टीम की विजिट को हम कंपलसरी कर रहे हैं।
Poor conviction rates aside, the Modi government has pointed out that there were glaring inadequacies in the Indian criminal justice system. Citizens are running from pillar to post for justice, suffering inordinate delays in the courts. There is overcrowding in jails, and even false cases are being slapped while the powerful often go scot-free. The entire criminal justice system till now has been an archaic and not in tune with contemporary times. But if implemented in letter and spirit, the changes suggested are landmark. At the end of the day, the proposal to overhaul the criminal justice system is a much-needed reform.